on 27, Malab, what happened? Several locations, this matter was directed to be listed. It was not listed. I inquired, the file could not be traced out. Malab, later on, I verified, they located the file. There is an urgency, can it be on 27, Malab?
Let us see. May not be on 27. We have already numbers of cases. 29.
Well, my humble prayer, otherwise I would not oppose your lordship. It was directed to be listed on 21st. The file could not be traced out. I have an urgency. That is why I am before your lordship. On 27, Malak.
Mr. Goodswami,
The matter, the lower court matter is fixed on 27, Malak. If it was not taken up by your lordship on 27, I am, Malak, there will be difficulty, Malak. That is why my prayer, humble prayer for lordship on 27, Malak.
Today at 2. Yes, Mr.
Hello,
Goods.
I beg to mention item number 16, my lord. But here my petition are expired, my lord. But date has not given to me. 3 years ago, he has expired.
Mr. Last, let's for a few minutes. After the mentioning, we'll pass the order.
Yes, my lord.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 14 of today's list. In this case, I'm being led by Mr. A.M. Bora. He had, for some personal reason, he has to leave for Shillong today. So he
What
has,
do you have to say?
Your lordship may make it at their request. And personal difficulty, I can't really object. But
Yes.
your lordship may make it at their request. And I'm also requesting for a specific date subject to convenience of the court.
We can give you a date. On that day, what will happen?
No, but the matter is urgent in
We
the sense that the trial has been held up in the matter.
9th.
Could it be 10th?
10th is a hearing day.
11th? 11th?
lordship, 11th, I'll be in Majuli. So
That's why, what's the point of 15th?
Then any date, any date.
9th or
It can be 9th also.
9th.
13th.
Obliged, deeply obliged.
Obliged. Interim order may be continued, lordship.
Okay.
Deeply obliged.
Lordship, I pray for listing of a matter of criminal petition of 2021. It was listed on 15th May, your lordship. Any date, your lordship, admission it will come.
3rd,
3rd of September.
not 3rd, 3rd is a Tuesday. 6th.
6th.
Yeah, please, your lordship. Lordship, item number 4, my lord. The affidavit in reply will be filing it tomorrow, my lord. I may pray for little accommodation, my
Your
lord. 2
lordship
weeks.
had given time on the last date that it should be filed by 12th of August.
My
That
lord,
was
due
kept
to the
today.
notary thing, my lord, that same has been coming from Dibrugarh, my lord. And my lord, yesterday CWC has filed their affidavit. So we need to file the reply to that.
When is that matter we have fixed?
13th, you know,
Same day.
obliged.
It will be coming, that's why it will be.
Deeply obliged.
Deeply,
But you will be filing your reply on or before 10th.
my lord, my lord. Deep,
No further time will be granted.
sure.
May I please, your lordship? I beg to mention item number 10. I have a consent, lordship, other side. This matter may be adjourned for today, lordship.
After 2 weeks, we'll get to the page.
May I please, your lordship? I beg to mention item number 7 from today's list, my lord. With the due permission from the other side, my lord. Kindly pass over the matter for today, my lord.
May I pray that the date will be 16th September because 16th September, your lord.
I'm deeply obliged.
Sorry, so just a minute. Yes, fine. 16th September.
Deeply obliged.
There will be council for today.
May I please, your lordship? Lordship, I beg to mention item number 26, lordship. Some accommodation on behalf of Mr. A.M. Bora, lordship, is out of station. The causes also reflects. I have taken the consent of PJ Soikia, lordship. Item number 26,
It's a hearing list. Don't see.
lordship.
May I please, your lordship? Your lordship, I beg to mention for listing of a criminal petition which was ordered to be listed after 2 weeks, but did not get listed. Any date on the last week of this month, your lordship. Any date as your lordship may deem fit.
38.
Much obliged.
Sorry, please, your lordship. I am praying for listing, my lordship, for it is a Zima petitions, lordship. Notice was issued. So, lordship, next week, lordship, any date.
It will be on 30th, 30.
Sorry, lord.
30th, 30.
Lordship, I have another matter, same matter, high necklace.
Lordship, I'm praying for listing of an IA for suspension of sentence and grant of bail, your lordship. This filed in 15th of July. For any date, your lordship. In the coming week, if possible,
29th.
29th.
May I please your lordship, I beg to mention for listing a criminal petition 1049/23. It was last listed on
Sir,
30
can you tell us for which to be listed for orders for?
for orders.
Thank you.
May I please your lordship?
Will come on 2nd of September.
May I please your lordship? Lordship, with concern with the other side, I beg to mention item number 27. Lordship, this matter may come up after a week, lordship.
Lordship, a short date may be given.
We are not giving any date at this stage. The time, because these are hearing matters. Full hearing, we're not passing any order at this stage. Okay? Yes. Well, at the time, if the matter reaches, then we'll pass the order. Don't worry.
I beg to mention for listing lordship, a criminal petition of 2021 lordship. It was last listed on 23/11/2023.
Sir, kindly tell us for what? For
Orders, my lord.
You should tell us.
Can it be on 10th September, my lord?
For that, you make a mention in the first week commencing from 2nd, not before that. Not before. If you want on 10th of September, you make a mention on 2nd.
No, my lord, any date, my lord, any date.
Second, yes.
Lordship, I beg to mention for listing of an IA for orders, lordship. In IA in connection with criminal appeal number 141/24.
I is for what?
IA for suspension of sentence and consideration
On
of bail.
29th.
29.
Lordship. Lordship, I
Deep
beg
level.
for listing a criminal revision petition, Lordship, in orders column, Lordship. Any date, Lordship.
Orders for why? Why want to list?
Lordship, I am for the respondent, Lordship, and Lordship, maintenance is not paying, Lordship.
Okay, on 3rd.
May I please, your lordship, item 7 has already been mentioned and 16 September has been fixed. Only there is a stay order, so that may continue, your lordship.
Alongside.
Obliged.
Das, where are you?
16. I am calling.
Not necessary. Heard Mr. H. Das, London Council for the petitioner slash accused. And Mr. B. Sharma, additional public prosecutor Assam for this opposite, sole opposite party. On instruction, Mr. Das, London Council submitted that during pendency of this revision petition, the petitioner has expired in pure paper. This criminal petition stands closed due to evidence. Registry, sir. Send back the records of the interim order passed earlier on 17/06/2011 in connected criminal MC number 407/2011. Hence marked with disorder.
Okay, now I'll give it. Huh? Okay.
No. Purva. Very tough part আছে দেই। এটা secret. Run করে দিতে। Very good. Send on the records of criminal appeal number 2/2009. Along with a copy of this order to the Court of Learned Sessions that's Valpara. Similarly, the registry shall also return the records of GR number 496/2007. Arising out of Dudnoy PS case number 78/2007 to the Court of Learned Chief Judicial Magistrate Valpara along with a copy of this order. দুটা separate. দুটাই বলি এটা পিসের মধ্যে তো পুরো তো
Item number 35. May I please, your lordship? I am on behalf of S.K. Nur Muhammad.
What's your good name?
My name is J.S. Ahmed. Lordship, I am
Mr.
trying for
J.S.
withdrawal
Councillor
this
Karim
petition.
Zain Ahmed on behalf of Mr. S.K. N. Muhammad, counsel for the petitioner. RMS as Sahan London Additional Public Prosecutor Assam for the opposite party, state opposite party number 1. On instruction of the petitioner, Mr. Satyan Sachs, appearing on the praise for withdrawal of this petition. The counsel for the party respondents have no objection. Correct. Petition stands dismissed. Being not placed.
Item number 6.
May it please, your lords.
Yes, Mr. Busso, what happened?
My lord, in earlier occasion, my lord was pleased to direct the IO and the OC concerned to be present before this honorable court today. He himself is present, lordship, and along with the order. And lordship, there is one mistake in my part also, that lordship on the same day, but it was late at about 4:33. I was received the instruction from the office, but till then, lordship, the matter has already been taken up. And
You could have mentioned the very next day.
my lord,
You could have mentioned very next day or on
lordship,
16th.
lordship. And lordship, he has informed us because that day is 14th of August and due to law and order duty.
Prior to that, he did not send.
Yes, lordship,
It
because
was sought from some earlier dates, right?
lordship,
So only when the personal appearance is given, you get all the instructions. That
lordship.
means we have to pass orders directing the OC and the IO to be here in every case.
Lordship.
Is it?
No, Lordship. No.
Why are not the OCs and the IOs are not cooperating with the public prosecutors? What is the reason?
Lordship. I got a patient.
Why? Why they are not sending the records?
Sir, আগতে পোৱা নাই, sir.
What is the mode of communication?
Lordship, we have sent over telephone and also that the same date on the first, that day he received. He said the earlier occasion they did not receive.
That's why I'm asking you, what is the mode of communication?
Mode of communication, Lordship, WT message to the office will send it.
You're still in the Mandhata days, sending WT message.
What I was thinking. Message, perhaps to
Still going on WT message.
WT te pathai. WT pathai. Yes, Lordship.
Still,
Lordship.
Assam police has not updated.
Lordship.
They mail also. I think they send by mail also.
Telegrams have
Some-
stopped.
we from ourselves send Lordship. When
How many post boxes you are seeing in the roadside nowadays? Post box.
Lordship.
Have you, do you noticed?
Lordship.
In the Guwahati, how many post box you have seen on your way to home?
Lordship.
How many?
Lordship, negligent.
Not a single.
Not a single, Lordship. Not a
Is
single.
there any process of telegram by the government of India? There is no telegram.
No.
It's other more provisions are there in the
My Lord.
net, right?
Even now
So you are
electronic
still forcing the
communication.
government to have the WT message.
No.
Ms. Jahan, government is placing budget in tabs
Yes.
It's a very confusing.
and they are informing the police department in WT message.
This is what is so surprising.
Surprise means it is
In
something.
fact, I personally mail or I send it by WhatsApp. This is, I don't tell my office people to do. But I'm told that there is a particular person is assigned from the police side to deal with these situations, in our office also.
Is he regularly attending your office or leaving at 5 o'clock or what o'clock?
Not-
What time he is leaving?
I don't know that, but he keeps coming daily to our office.
Where in the other side, we used to
He
follow
will
the same
know,
system.
It's regular.
He is regular, he is staying here up to which time?
My lord, he came from Gowari, my lord, in my lord, 10, my lord, in 10, my lord.
By 10 he reaches,
10 he
perhaps by
reaches.
4:35 he leaves.
He comes from Tihu every day. He reaches here at 9:30, leaves at 5:30. After completing the work. So, your man leaves at Nalbari early, comes late, regular. You have the copy of this communication,
My Lord.
though we should not interfere with the investigation. Just one thing we want to know.
My
from
lord.
You, Mr. Busso.
My Lord.
First paragraphs, last 3 lines. It starts on the right side. Now they come to know.
Now they come to know that so and so seated them.
Implicating.
It should be either
That should be-
impersonating himself. It should be either impersonating or something. Okay.
Impersonating himself
Impersonating himself
as owner of the said goods and already released the goods from the court, submitting forged documents and sold away the goods.
Then read the last two paragraphs.
Uh, On receipt, the complaint case has been registered at so-and-so police stations under so-and-so sections and investigate into. In the course of investigation, neither any sufficient evidence nor witnesses were found against the accused person.
Now, only thing I want to know from you, as matter relates to submitting forged documents before court. That's why we are little. What is the investigation relating to the forged documents submitted before the court?
Hmm.
What was the investigation to that extent? See, matter relates to court, submitting forged document before the court. That is why we are asking you. Otherwise, it is not our duty to interfere with the investigation.
195 will come.
So, what are the steps the IO took to know about that? Can you tell us? Or did you ask the IO or the OC who is here?
OC himself is the IO, Lordship.
OC himself is
With
the IO.
IO,
Why-
yes.
You ask him what
Yes.
happened,
How
how he has submitted the FR.
Forged document যে কোৰ্টৰ আগত দিয়া বুলি কৈছিল সেইটো কি হ'ল আপোনালোকে এফআইআৰ যে দিলে সেই কোৰ্টৰ আগত ফৰ্জ ডকুমেণ্ট দিয়াটো সেইটো কি কৰি
Force document দিয়া হোৱা নাই।
দিয়া হোৱা নাই
Take it.
Please,
Yes, ma'am, please take your seat.
কি হৈছিলে আপুনি ইয়াত লিখা মিনিংটো সেইটো
Sir,
ধৰণৰ
হেৰি
মাই লৰ্ডত কওক আপুনি
No, no, you ask because you're not supposed to know about the investigation.
Only
Only interested
Vijay-
because submitting forged document before the
সেইটো যে আপুনি লিখিলে ফৰ্জ ডকুমেণ্টটো তাত দিয়া বুলি
নাই এইটো হেৰি এজাহাৰ কপিতহে তেওঁ উল্লেখ কৰিছিলে।
আচ্ছা
গুচৰীয়া উল্লেখ কৰিছিলে, এজাহাৰ কপিত
কিন্তু
উল্লেখ
তাতে
কৰিছিলে।
কোৰ্টৰ আগত ফৰ্জ ডকুমেণ্ট দিয়া নাই
ডকুমেণ্ট দিয়া নাই। আৰু বিজয় আছিলে কিমৰ্তনী,
Yeah.
বিজয় কিমৰ্তনী, তেওঁ চুপাৰীৰ এক্সুৱেল অনাৰ আছিলে।
আচ্ছা
তেওঁ হেৰিৰ পৰা আৰ পি এফত তেওঁ হেৰি কৰিছিলে, চিজ কৰিছিলে। এই চিজ কৰা বস্তুটো তেওঁ অকশ্যনত লৈছিলে,
আচ্ছা।
অকশ্যনত কিনি লৈছিলে। অকশ্যনত
কিন্তু
কিনি লোৱাৰ
court-
পিছত তেওঁ এই জয়প্ৰকাশক তেওঁ দায়িত্ব দিলে যে ট্ৰেন্সপৰ্ট কৰিবৰ কাৰণে, নাগপুৰত ট্ৰেন্সপৰ্ট কৰি লৈ যাব।
হয়।
তাৰপিছত জয়প্ৰকাশে কি কৰিলে, তেওঁৰ গুডাউন আছে চকীগেটত, তেওঁ চকীগেটত গুডাউনত থৈ দিলে। গুডাউনত থকা বুলি গম পাই আমাৰ পুলিচে তাতে গুডাউনৰ পৰা চিজ কৰিলে বস্তুখিনি। চিজ কৰাৰ পিছত আকৌ কেছ এটা হ'ল, এই কেছটোত হ'ল। তাৰপিছত বিজয় কিমতে কৃষ্ণা নাই, তেওঁ হেৰিৰ পৰা জিম্মা ল'লে, কোৰ্টৰ পৰা তেওঁ জিম্মা ল'লে। জিম্মা লৈ জয়প্ৰকাশক তেওঁ ট্ৰেন্সপৰ্ট কৰিবৰ কাৰণে নাগপুৰলৈ দায়িত্ব দিলে। এতিয়া এই চাটুৱালে যিজন হেৰি কৰিছে তেওঁ ট্ৰেন্সপৰ্টাৰ মানুহ, তেওঁ কিন্তু নোপোৱাৰ কাৰণে তেওঁ মানে হেৰি কৰিব, হাৰাশাস্তি কৰিবৰ কাৰণে তেওঁ দিছে।
এজাহাৰ দিছে।
একচুৱেল অনাৰে একো কমপ্লেইন কৰা নাই।
আৰু তই এজাহাৰত তাতে লিখিছে ফৰ্জ ডকুমেণ্ট
ফৰ্জ ডকুমেণ্ট দিয়া বুলি এজাহাৰতে লিখিছে। এইটো
What is the
investigation
inquiry about that regarding the submission of forged document before the court?
এই
That's
যে
what we want to know.
কোৰ্টৰ আগত যে ফৰ্জ ডকুমেণ্ট দিয়া বুলি কৈছিলে তাৰপিছত আপোনালোকে ইনকুৱাৰী কৰিলে নে নাই তাত
আমি কৰিছোঁ, তেওঁ ডকুমেণ্টছ দিয়া নাই।
ডকুমেণ্টছ দিয়া নাই পাইছে
ডকুমেণ্টছ তেওঁ ফৰ্জ ডকুমেণ্টছ কোনো ছাবমিট কৰিব পৰা নাই।
My lord, IO has stated that after receiving that complaint, that forged document was used, then thereafter they made an inquiry, they found that there is no such document just provided. That is the allegation in the FIR.
Yes, Ms. Nazneen, you have seen, you have heard probably.
Yes,
You
sir.
understood the IO come OC.
Yes, Your Lordship. Here in the FIR, Lordship, they have stated that
That is a different issue. You will have an ample chance in the appropriate forum.
Your Lordship, as the FIR has been submitted, Your Lordship, the FIR may be quashed, Your Lordship.
Heard MS Nazneen Learned as counsel appearing for the petitioner. And Mr. K. Boysel, Learned Additional Public Prosecutor, Assam for the state, respond number 1.
Chief for the informant.
Also heard MS SSZR, Learned Counsel for the respond number 2 informant. The respondent number 2, as an informant, lost the written Azahar before the officer in charge of Sangsari police station. On 17/11/2022. Stating that he works as a broker for Vijay Kimmat Rai Krishani, a betel-nut businessman and resident of Nagpur, Maharashtra. Said B.K. Krishnani purchased betel-nut in a government auction in December 2021. After such auction purchase, he asked said B.K. R. Krishnani to keep the responsibility of transporting the items to one Sri Ganesh carrier from Krishna carrier to Nagpur. Pursuant to the same, the owner of said Sri Ganesh carrier pursuant to the same petitioner, the petitioner, owner of Sri Ganesh carrier, Sri Krishna carrier, took the goods on his custody and stored them at his own godown at Sila Soki Gate near RJ Nursing College. The informant in the affair stated that after a few days, the petitioner informed him that the auction purchaser Vijay B.K. Rai Krishnani informed that, told him that the police seized the betel nuts and sealed his godown. And the petitioner asked him not to come to Assam, stating that police were searching them in the case. And was also informing them that the petitioner could not release the goods from the court. Subsequently, the informant came to know that the petitioner cheated them impersonating himself as the owner of the seized goods and release those goods from the court, submitting forged documents and sold them. As such, the informant, respondent number 2, in the said FIR dated 17/11/2022, submitted before the OC Sansari Police Station that the petitioner cited him requesting the said authority to take necessary action in that regard. Right. The said written FIR of the informant respondent number 2 was registered as Sansari Police Station case number dated 17/11/22. Respondent number 2, 17. As Sansari Police Station case number 442/2022 under section 419/420/407/468/471 IPC. Aggrieved by such registering a police case against the petitioner corresponding to GR 1647 green bracket K bracket 2/202.
दिलीप ना तो का रामचारी और रामचारी कम हो
Okay. এতিয়া আহিব আপুনি এপাৰ আপুনি
मैं अपना तो
ট্ৰান্সফাৰ
फोरम को तो थी
এইটো দিলীপ আপুনি ট্ৰান্সফাৰ দিলীপ
रिटर्न কোনো কমপ্লেন নাই বিজয় টিমত টিমে কেনেকুৱা এই দুজন ট্ৰান্সপোর্টার এই ট্রান্সপোর্টার এই ওয়ার্ড জয়েন করে এই ট্রান্সপোর্ট করব না পায় এই
By pressing a copy of the order dated 20/07/2022 passed by Learned Additional CJM Kamrup Amingao in Sansari PS case number 55/2022. The petitioner submitted that Zimma of said seized Betelnut from the godown of the petitioner amounting to 37,922 kgs of was given to the actual owner, to its actual owner, Mr. V.K. Krishnani at rupees 1,50,00,000 to the satisfaction of the concerned investigating officer of the of said Sansari PS case number such and such. And as such, he is no way connected with said Sansari PS case number such and such. Therefore, he had filed this criminal petition praying to pause and set aside the proceeding of said Sanctuary PS case number 442 of 2022. By order dated 22/08/2023. The court called for the records of said Sanctuary PS case number 442 of 2022. Thereafter, on 26/09/2023, (29/07/2024), the court asked for the case diary. In spite of such orders, the case diary leading to Ramya PS case was not presented before. As such, on 14/08/2024, the court directed the officer in charge as well as the investigating officer of said Chancery PS case number 442 of 2022 to remain personally present before the court today. Pursuant to the said order of the court dated 14/8/2024, Mr. Sachin Church, the officer in charge of Chancery Police Station, from investigating officer of said Chancery PS case number 442 of 2020, personally appeared before the court, stating that he did not receive any information earlier regarding production of liquor. Relevant case will be. However, Mr. The concern I come OC of Sanctuary Police submitted that in December 2020, a final report has been submitted before the Planet Season, Amingaon, in State Chancery Police Station. Mr. K. Boysel, an additional public prosecutor, have placed the communication dated 14/08, submitted that on 14/08/2024, in the later half of the day, the Office of the Public Prosecutor received the communication from the officer in charge of Romania Police Station pertaining to say Romania PS case, which however could not be placed before the court, as the relevant matter was already over. From the said communication of the officer in charge of Romania PS dated 14/08/2024, Mr. Boysel, an additional public prosecutor, submitted that after completion of the investigation, as no such sufficient evidence or witnesses could be found in the matter against the petition. Therefore, by FR number 221/2023 dated 31/12/2023, the OC of Sanctuary Police Station submitted the final report in same. Right. in view of this criminal petition being in process stands dismissed. However, the officer in charge of Sangsari Police Station present before the court has been asked to comply with the court's order forthwith. Hence, put it along. Ms. Zia, since the matter has an FIR in file here, you'll be getting an opportunity. As of now, you have to, but it will be receiving a notice.
Submit a protest petition.
Mr. Boyser,
My lord,
ask the OC
my lord.
whether he sent a communication to the informant regarding the filing of the FIR.
এইটো ইনফৰমেণ্টক জনাইছিলে নে এফআইআৰ হোৱা বুলি জনাইছে কমিউনিকেশ্যন কৰিছে he has informed he said that
What is the process of information?
WT message
Don't say WT message every time.
No.
no he said
Notice.
কেনেকে জনাইছে
Processor.
নোটিছ দিছে নে
WT মেছেজ আমি যেতিয়া এফআইআৰ কৰিছো তেতিয়া আগতে নটিচ দিছো
মানে এফআইআৰ কৰাৰ পিছত WT মেছেজ দি জনাইছে
নটিচ দিছো
নোটিছ দিছে থ্ৰু WT
Your lordship. Your lordship, the kindly matter be not be disposed, your lordship, kindly be kept in admission, your lordship, because since the FIR has been submitted, your lordship, the FIR has not been quashed yet, your lordship.
That at this stage cannot be considered. That will you thereafter will see. You can come only.
My lord, no, this photo from that. My submission may be recorded that we have not received any notification.
Ms. Zia, learned counsel appearing for the informant respondent submitted. That she has the instruction that the respondent number 2 informant has not yet received any information regarding the submission of final report in said Sangsari PS case number such and such that was registered on the basis of the FIR lodged by the said respondent on such and such. Copy of the communication dated 14/8 submitted by the officer in charge of Rongya PS case. Rongya PS case BK plays a part of it. Mr. Boyser, ask him to comply with the court's order forthwith.
my lord Thanks, got to be done. Stop it.
Ms. Zahan, what steps are government taking in training these police officials when the matter relates to court? See, basically, I don't know. You can advise the AG or someone else. The reason is that we found in various cases.
I cannot hear your lordship because of the noise perhaps. Lordship.
No, what we want to know just whether the government is giving proper training to the state police.
That of course the process was going on since
The
long.
thing is this, who are the investigating officer
Ah.
or the OC? This is not the first case.
So many.
We have been seeing that we are not getting case diaries from Satgao, Dispur,
This poor Chanmari.
that
This is-
PS Road, many other police station in and around Guwahati, right?
What is the difficulty in
So
sending?
what is the reason behind? And they are not complying with the court's order.
There are so many orders for
So
that.
what steps government is taking?
I have to talk to the public prosecutor. He'll know, but the training and all were going on. I mean, off and on. That I'm not sure. I'll tell Mr. Makhon to be present here and apprise your lordship.
No, because you have seen, otherwise we do not like to call any OC or IO to report because they are in the law and order situation, they are busy. The thing is, we found that this is not the first case.
There cannot be any excuses, but the law and order and investigation is not separated. So they say that they don't have enough manpower and enough time. But that cannot be an excuse.
And the process of communication to the concerned police station, do you know how come you do not have that process?
Mm.
But you should also insist that the FIR, when it is FIR is accepted or filed, the informant must provide, just like we have issued a notification,
Mm.
the mobile number or communication number. It should be more than 90% of people are having now
Mm.
the at least a phone number, right? So you have to tell them that that procedure should be invoked by the government.
The notices and all should be served by a process server. Somebody has to go to his or her place and
So
serve
how
the.
do you communicate to the police station? If court passes any order
Mm.
asking you to submit certain materials from the police station, how do you communicate?
That is what the process is, that we have some staff here and they sent a letter to the concerned police station. Like in service cases, we sent letter with the petition copy to the police station. But most of the time, police people says they have not received. Again, we sent it through WhatsApp and all. There is a difficulty. Things are not so constructed properly.
Okay.
There has been so many instruction to from the court to build up some stations and then provide email address of all the police stations, but that has not been done as yet.
We'll look into that.
Not.
May I please your lordship? Also, for it, it's daily application. This case, earlier anticipated bill was rejected by this honorable court.
They have not annexed it with the
Yes,
petition,
I-
but the requirement is that they have to annex the order.
So.
They have mentioned it in the pleadings,
Yes.
but they have not annexed.
Without the order, কিহৰ কাৰণে মাতিব দেখোন কি বোলে কথা হ'ল নেকি It's ready. Now, problem to current.
Be orderটো আছে নি আৰু? দুটা কপি গ'ল এটা। কিশোরী কিশোরী
When it was rejected earlier?
26/6/2023.
That was AB.
I was now I was arrested on 25/7/2024. Today 29 days in custody.
304B is there. For the girl died. She had two daughters.
Minor.
Hmm.
Where you have? Yeah. Had Mr. M. also reporting for. And I'm at Sajja Hunt. And result of prosecutor appearing for the state. Earlier, the previous bail application of the petitioner in Gosaigaon PS case number 33 of 2020 under section 3040 was rejected by this court on 26/06/2022. The incident occurred on 17/01/2020. FIR was lodged the same day. And the petitioner who could be arrested only on 25/07/2024. Inside Gosaigaon place case number. Hence this bail application by the petitioner. List on when up to date.
Lordship,
We're not asking for the up to date case, there is status report, that's all.
otherwise,
Details,
Lordship has mentioned what was there in the case diary in the AB's.
that we will not say anything at this moment.
Haha.
You have the up to date because it's a
Yes,
PA.
up to date case diary,
Up to date status you get
status report
along with the report.
along
We
with
don't
the.
have the required the case diary because in earlier occasion we have already seen.
Hmm. Postmortem report and all have been seen. Now, any date, Lordship will, this is 22nd, no? 30th or
Won't come
3rd of September?
from Gosaigaon.
Hmm.
Will it come?
Police officer, the police personnel, they keep coming from that place. 3rd of September.
Fine. List on 03092024. And I'm linked the concerned investigating officer of Gosaigaon PS case number 33/2020 to place the up to date status and report relating to the investigation of the safety
In number, status report.
along with a copy of the postmortem report of the deceased.
Lordship is the
Not.
3rd.
A copy of the sorry.
May I please allow? Lordship may kindly peruse IA criminal 753 of 2024. Item number 2, Lordship. In this case, Lordship, IA Lordship, this is a joint application filed by the petitioner and as per number 2 under section 147 of the NI Act, Lordship. Matter has already been settled outside the court, Lordship, and the entire amount is already received by the respondent. Therefore, we filed a joint application. And Lordship may kindly see the annexure 1 and 2, page number 9, and Lordship in page number 12.
in a complaint petition filed by the respondent number 2 under section 138 of the NI Act. Related section 140, a complaint, a complaint. Under section 138, related section 140 of the NI Act, one before the Illinois Chief Judicial Magistrate Sonitpur Tezpur against the petitioner. Case being CR number, please take your 307 of 2011. Was registered. After hearing the parties, the learned additional Chief Judicial Magistrate by judgment dated 05/01/2018. Convicted the petitioner under section 138 of the NI Act. And imposed a sentence of fine of rupees 6 lakhs. That includes the check amount and a lump sum amount of interest. Come on, in default, rigorous imprisonment for 6 months. With the observation that the entire fine amount shall be paid as compensation to the complainant, i.e. the respondent number. Agree with the said judgment dated 05/01/2018 passed by Learned Additional Citizen Sonitpur Tezpur. The petitioner filed its revision petition. No, against the said order of the Learned Additional Judicial Magistrate dated such and such. The petitioner preferred an appeal before the Learned Session Judge Sonitpur Tezpur in criminal appeal number 5 within bracket S-1 of 2018. After hearing the parties by judgment dated 29/06/2018, the Learned Additional Session Judge within bracket FTC Sonitpur Tezpur dismissed the said appeal of the petitioner upholding the order of the 29/06, upholding the order of the Learned Additional Judicial Magistrate dated 05/01/2018, passed in said CR case number such noted. Aggrieved, the petitioner filed this civil criminal division petition. Which highly. While issuing notice, the court on 14/09/2018 stayed the impugned judgment and order dated 29/06/2018 passed by Learned Additional Session Judge Sonitpur Tezpur in criminal appeal number 5 within bracket F-1 2018, as well as the judgment and order dated 05/01/2018 passed by Learned Additional Session Sonitpur Tezpur in CR case number 307. By filing the connected interlocutory application, both the petition, the respondent number 1, jointly made a prayer under section 147 of the NIAC 1881. Read with section 359, within bracket 8 of the BNSS 2023. Stating that the respondent number 2, complainant, on 10/10/2023 received an amount of rupees 4,00,000,000 from the petitioner to his final and full satisfaction, full and final against the check number 087518 dated 12/08/2011 issued by the petitioner relating to said CR case number such and such involved in this said petition. And as such, both of them jointly submitted that the impugn orders 501/2018 are of criminal appeal be set aside and cost. Since the complainant, respondent number 2, received the amount of rupees 4,000,000 from the petitioner accused on 10/10/2023 to his full and final satisfaction pertaining to the check involving the said complaint case number such and such, CR case number. And both of them, both the petitioner and both the respondent number 2 and the petitioner have settled the dispute outside the court. That has been placed before the court by them by filing the such and such in exercise of the impugn judgment and order dated 05/01/2018. CR case number 307/01. Essential petition as and the consequence appeal. Criminal appeal number 05 within bracket @1 2018. Judgment in order to complete. Judgment. 29/06/2000. Set aside. The interim order was earlier on 14/09/2018. Hence, March the case on. According to the set. Cancel out that. Registries have communicate this order to the court of London. Additional section that's the additional civilization and legislative test. Need for that.
Obligers.
Lordship has closed the matter.
Obligers.
Item 3, this is a matter on cancellation of bail. On the earlier.
Yes.
Yes. No, I mean, as far as I could understand, this is a case on cancellation of bail. Lordship on the earlier occasion has told me to find out whether any FIR and all were lodged after the bail was granted, because they say that they have been threatening the witnesses and all. But I asked the Lakhipur police station people and they said that no FIR as such is lodged. Neither I can find it in the pleadings. Pleadings also they have not stated. I have told them to find out whether any GD entry and all are there. They are yet to find out there was a transfer in between. So Lordship can take it up on Monday if they have some other instruction.
Lordship, we have filed the FIR 28/4/2023, and last occasion, Lordship was pleased to direct the IO to submit the report as regards that FIR, Lordship, subsequent FIR, Lordship.
Acha. Let me get the instruction because there was a transfer in between. So Monday Lordship can take it up. And what has been done in this, in respect of this FIR, I'm yet to know from them. A2. Register, probably won't I don't. Register, who said received? Received but not registered, no?
Registered.
Perhaps they, with the new IO, he doesn't know about this. No, I don't think it is that. Yeah.
It has been registered.
It's
What
not,
is the case number registered?
Not Lordship,
Not yet registered.
not yet registered.
but it was received by the
Huh.
OC,
Perhaps there
Lordship.
will be a GD entry, so I've told them to find it out.
Okay. Later. On the prayer of Ahmed Fazjan, our additional public prosecutor. Place this matter on second,
Lot.
and
Second.
it's in her to place the relevant instruction in the matter with regard to the lodging of an affair by the petitioner on 28/04/2023.
Obliged.
Five, yes, there is the case is returned in FR. Lordship wanted me to find out.
Ma'am,
My lordship, I am praying for adjournment, my lordship,
why?
because my lordship, the counsel of the petitioner has to leave the court, my lordship, because of some personal difficulties, my lordship.
Police and will be given all again for it.
Yeah.
Magistrate is the
Oh, magistrate has to give.
Yes.
Yes, in fact, I stand corrected. As far as notice to the informant goes after FR is submitted, it should be given by the magistrate, not the police, I think.
There is a provision.
Not the police lot.
Why?
There is a.
Because
one-
lordship, yes, the
one-
provision
one
is,
High Court judgment.
no, it is provided in the statute itself.
And also.
173? There is
Ah.
a provision,
Yes, there is a provision. So,
not only provision, I think so, there are judgments also in that regard.
judgments there are, but provision is also there.
Provision is also there, lordship.
What is it? 200.
Posted in. MDB.
Huh? Mm,
And yes.
Come to 173 to
lordship,
Roman 2. 173 to Roman 2.
170.
Police have to file a report under section 170 of the.
No, it's 173, 1,
70.
2, Roman 2.
Hmm.
The officer shall also communicate in such manner as may be prescribed by the state government. The action taken by him to the person, if any, by whom the information relating to the commission of the offense was first given.
So
This
is
is,
bound-
of course, this is a general provision in case of any action. But as far as, I mean, informing about the FR, I think it is the
There are
magistrate.
judgments.
There are
Yes.
judgments.
There are judgments.
Their judgment. Our High Court judgment is also there, lordship. Pinaki Devi Daksa State. First April 2000.
You'll be knowing better.
Lordship?
You'll be knowing better.
Lordship.
You can guide Ms. Zahan in that regard
Sorry, lordship.
with your experience as a PP.
Mm.
Lordship, just while I was hearing it, my case is also. For which lordship I was asking my friend lordship as a PP lordship. Magistrate first step to issue notice lordship. To the informant.
Now you have the information that the Karimganj PS case number 389/2002 has ultimately been FR.
Yes,
FR.
FR number 335,
We'll note it down.
Lordship.
Haven't you done?
No, Mr. Majumdar has earlier on occasion has informed, but
Ah.
we wanted to know about it.
Yes,
He has now.
he has
want to-
stated it correctly. Even the number and the date he has stated correctly.
You are decollector, right?
On behalf of Mr. Dekolita
What's your good name, ma'am?
and Barman, my lord.
And counsel appearing on behalf of Mr. Decollector, counsel for the president. Also heard MSS Jahan Listen for the prosecution. Appearing for the state response number 1.
Jonaki
Mr.
Devi.
K. M. Majumdar,
এখানে
K. A.
photo মারি দিও।
Counsel for the response number 2 informed.
এয়া লিপালে পাইলো আপুনি নিজে না পালো
On due verification,
জুলি বুলি কৈছে জুলি এডভোকেট
Sir, I got
ফটো
it.
মাৰি দিলে মই পালো মই
The matter relates to
প্ৰভিজনো আছে ক'বা প্ৰভিজনটো
Provision 170 আছে হেৰি
না 173 টো পুলিশ আৰু
now 170
Passing and set aside. Proceeding of Karimganj PS case number 389 of the 2022. Registered under section 120B oblique 420 oblique 406 oblique 467 oblique 468 oblique 471 oblique 294 oblique 506 oblique 34 IPC against the
judgment.
petitioners on the basis of the FIR laws by the response number 2.
Give notice to the informant and provide him the opportunity to be heard.
এইটো he has written it on Bhagwan Singh
Bhagwan Singh.
has to forgive
On the basis of
and
a
provide an
complaint
opportunity.
laws by the
It was
response number 2
give notice it
being
Bhagwan
CR
Singh no
591 oblique 202.
Bhagwan Singh
Singh to that judgment to accept.
no it 170 is charged কিন্তু মিনিষ্ট্ৰেটে ক'ত দিব পাৰি ক'ত আছে
এই hearing case চলি আছে।
নহয় নাই এইটো ভগৱান
ভগৱান পিছতো আছে একদম পুৰা কাট কৰি
1188 W2 2022.
নোটিছ ইয়াতে আছে
উল্টা করে দিই উল্টা করে দিই। The response number 2 filed a complaint petition Deputy Court of London Chief Judicial Magistrate Karimganj being CR 591 oblique 2022 against the petitioners.
তো ভালকে হৈ জোনাকিতে ওলাব
কেতিয়া ওলাব
নাই এতিয়াতো আৰু টাইম লৈছো এতিয়া বাদ দিয়ক বেলেগতো এইটো এতিয়া কি হ'ব এতিয়া
Alleging their involvement.
এইটো ক্লোজ হ'ব
আমার ট্রু
Question of the file.
No.
So this is returned in the file.
রিপিট করতে পারবো না।
And submitted to the land register. To forward the said complaint to the Karimganj Sadar Police Station
এইটো কি কথা এইটো কি
with a direction to arrest the accused persons
লাস্ট
নহয়
and to seize the relevant documents and the Asmali property and further to cancel the fraudulent deed of power of attorney and the sale deeds executed by the accused persons and to award a temporary punishment to the accused person for the ends of justice. The additional Chief Judicial Magistrate Karimganj by it's ordered it in 522 forwarded the said complaint to the Karimganj Police Station for registration of the said complaint as an FIR to investigate the matter and to submit the report in the final. On the basis of the sale order, the London Police District, additional CJM regarding the detained fact of the said written complaint of the respondent party was considered an FIR and Karimganj Police Station case number 389/2022 under section was registered against the present petition. The petitioners after inquiry is made in said Karimganj PS case number such intention. On this book on 06092022 in AB number 2581. Now they have filed this criminal petition for passing and setting a sentence. Right. While issuing notice the court by order dated 19/06/2023. State the further proceeding on said CR case number 591/2022. The FIR which was considered as criminal space case. Next letter. Ms. Azhan, are a resident public prosecutor. On instruction from the officer in charge of Karimganj Police Station Subject that after investigating the matter, Karimganj Police filed a final report. Karimganj reported not finding any sufficient materials against the petitioner to proceed with the investigation of the said person's police case. Submitted final report in said Karimganj PS case number such as which. Do you have the number?
Yes.
File number.
Number three, FR number 335,
Dated
dated 25/10/23.
in view of this criminal petition being in fact. What is the order passed by the court? What was the order passed by the court?
Lordship, implement of the victim, Lordship. Which item?
What was the order of the court? What was the order of the?
Lordship, implement of victim is.
See, normally you are not supposed to look after these court files till you are allowed by the court. Henceforth, don't do it. What's your good name?
B. Acharya.
Henceforth, you will not do.
Lordship.
The order is very specific. You are supposed to correct it or incorporate the name in presence of the registered judicial.
Lordship.
Who is the registered judicial here? And that order was passed on 30th of July 2022. Today we are 22nd of August 2024. more than 2 years. Mr. Asajji,
Lordship, the proper address of the victim is also not.
see,
available.
today, what will happen? From tomorrow, from the next day onwards, we will not allow any such bar member to look into the record. That's all. Will not allow. If you go on doing it. You are working under whom? You are practicing of your own or under some senior?
On my own, Lordship.
I think you have not done a proper thing. Henceforth, you will not do it, Lordship. And this is also me informing all the members of the bar. How can you change the record or incorporate something without taking leave of the court?
No
That's a
question.
disregard to the court.
That will lead to disastrous circumstance. Complete mess.
Yes, this is Mr. Asaji, this is not only a warning to you. This is also a warning to the members of the bar. If anything is reported to us, any of the honorable brothers or sister or his lordship, see, basically, these things can be stopped easily. Only to allow, because we are also from this other side, we know the difficulties we allow. But to that extent, it is. But if you go to these kind of things, then to. Yes, bar members present here, inform all your colleagues what happened here, so that it doesn't happen in the next occasion.
We will.
Yes, Mr. Asadji. Last and final. Transport will not be without taking leave of the court.
Obliged, Lordship.
There is nothing to be obliged here. No, not to issue তেওঁলোকে জানিব লাগে যে whoever it is. Training দিয়াও হৈছে নহয় ট্ৰেইনিং দিয়াও মই ফালৰ পৰা দুপৰীয়া লগ কৰিব পাৰোঁ তেখেতক
Item number 8.
Isdari was called on the last occasion, no, number of occasion in last occasion.
Eight. I think 8 was into offense.
Eight.
Not only eight.
Yes, Mr. Bora, you are agreeing because of investigation.
No, Lordship. Because of the taking of cognizance when the complaint itself makes out no offense, Lordship. The Lordship will find the complaint at page 22 and the order of taking cognizance at page 34. The only allegation is that the petitioner herein abused the complainant over phone using two specific words at page 23. Regarding the order of further investigation, your Lordship has already seen the contents of the Narazi petition. There is nothing in the Narazi petition filed by the complainant. The whole process is an abusive process, but the whole proceeding.
Yes, Ms. Jahan.
These are all over telephone
Tele-
from an unknown number, so 294 as such, you cannot be attracted, but 506 is again there.
But charge sheet is submitted under only 294 and
Achha.
cognizance is taken on under only 294.
294, otherwise
506, police did not find anything.
public places defined also.
Yes.
But telephone speaker number. I don't know, but people-
Oh, it is on that table.
Fine. Fine.
Nala yana OBC. Jodhuri. OBC. OBC. No, no, no.
Last time probably Miss Jahan, you have seen the protest petition of the complainant. Have you seen that? Do you remember?
They had no objection.
Oh, yes, I've seen. The last page that taken out. Yeah. Huh,
That cannot be a protest petition.
Lordship?
That cannot be a protest petition.
That cannot be without any details and all, only a one line, one paragraph.
Long back I have passed a judgment. I don't know whether it has been reported or not.
Hmm.
That's regarding the protest. Anyway, Mr. Bora, what do you have to say?
Lordship transfer to the FIR, my lord. Page number 22. It's absolutely clear, my lord, from that second paragraph. That suddenly the said accused person in the top, accused person, his name, my lord. And that telephone has come from the particular person. Abusing
Kindly read section 294 IPC.
294 IPC, my lord, that the 294 is that the public place here, my lord. But in the same time, my lord, the FIR cannot be an encyclopedia. Everything, not anything, everything. my lord.
Basically, we are not on that.
After, my lord, the FIR has been given, my lord. FIR and the FIR that then the objection was granted. Objection was filed, my lord. That objection only for that though there is a word re-investigation was given. There cannot be a re-investigation. But the court on, if notice comes to page number 26, as per laws 173A, further investigation was thereafter the FIR has been, the charge sheet has been filed. So
Now,
further
charge sheet has
investigation
been
is
filed under section.
294. That
Now,
will find in page number 27.
That is why kindly tell us the ingredients of section 294.
In fact, if your lordship peruses at page 28, the details of properties, articles recovered, seized during investigation, nothing has been seized. The phone which was alleged to be used, that is not seized, nor the SIM card which was used. Nothing. On what basis the trial will go? When there is apparently no ingredient of 294, lordship.
What are the ingredients of section 294?
It has to be public place
First
and
of all, it has to be public place.
yes, and obscene.
Right. And obscene language
Yes.
in the public.
In
Now,
fact,
the informant or the complainant, let us see his deposition before the police. Because from the reading of the FIR, you will see there is no mention. It was at 7:55 at night. And he did not mention where it was. To the provisions of 294. They did not mention where it should be, right? So, and cognizance also taken under section 294, Mr. Bora.
After further investigation was done, possession.
No. After the further investigation, after the filing of that protest petition,
Lordship.
the investigation was done and then 294. Initially, it was an FIR.
If initially it was enough, then at 294.
Then pursuant to the order of the London magistrate, on the basis of the protest petition filed by the informant. See,
Protest petition is filed, my lord. Though it is not so specific, but there is they have said they clear objective. Then under section 173, there is no specific that there is no provision for filing protest petition. Only after the Supreme Court order, my lord, the protest petition came up, my lord.
and that what should be in the protest petition? It is not a 4-line or 5-line protest petition. You have to mention.
Though it is not a so detailed, my lord, but
that is what is required in a protest. First of all, London magistrate should not have accepted that protest petition, or he should have given another sense, or might have recorded the statement of the informant under section 200 and converted to a complaint.
that can also be done, my
That
lord.
could have.
That could have done on the person.
But the London magistrate have accepted that protest petition, and that protest petition, as you have read from this, that cannot be a protest petition.
Only for the, they said the objection and he will prove the case.
That is why there are provisions are there in the CRPC. Now BNSS. See, ingredients of section 294, if you read, you will see very clear. First of all, it has to be a public place. Then obscene act in public place first.
Obscene telephone calls, obscene, saying obscene words, it is included in Post Office Act.
And
Not even in Indian Telegraph.
the sentence starts with to the annoyance of others.
To the annoyance.
Where is those ingredients, Mr. Bora? That is why public, there will be other public will be there in the place and committing those acts. Whether any obscene act and something in public space, it will be annoyed to the others present there in the public place. But here it is 294 will not come. And taking cognizance from the ingredients of that particular section. Leaving aside that what is petition. Right. That's the first sentence. Whoever to the annoyance of others. Where is this? Where is that ingredient?
At this stage, Lordship will not go into the nitty-gritty of the FIR as well as this, my lord. Only thing is whether this is, Lordship will decide whether this is the rarest or rare case, whether in the, under article, under section 482, Lordship can interfere.
Why not? Why not? This is a case definitely has to be
Lord,
entered under
as
482.
per
This is a case where
Bhajan Lal's and the
482
Niharika case, my lord, these
See,
are the whether these
basically,
ingredients are there, my lord.
charge sheet has been filed under section 294. The police did not specify the place. The return as a submitted before police doesn't specify the place. Where is that public place? Number one. And annoyance of others, yes. Telephone, definitely. The accused to that extent is something different.
Even if 294 is not there, if they can show some cognizable offense, that will do.
Definitely.
There is,
But here,
there is a,
294 may not be there,
but there is a threatening also to the
That has not been considered.
Absolutely.
And look at your protest petition.
Protest petition, I have seen it, my lord. There are only says
Petitioner
that
complains
is an object.
Begs to
Strong
submit
objection.
that he has strong objection for finding final report by police. His case is true. The complainant wants to contest the case.
And finally,
As such, the police final report be not accepted by the honorable. An order for re-investigation by a highest officer of the police department. of Uttar
reinvestigation
Pradesh.
cannot be further investigation.
He may not be aware, he may not be aware of the re-investigation of further investigation.
Lordship can remand it back when I'll file a detail.
That
objection.
cannot be done at this stage because already cognizance was taken. Cognizance taken on 17th of August 2023. And on the basis of that kind of protest petition,
Right.
22nd of March, magistrate forwarded the matter to the police station again for further investigation.
Further investigation. Well, Lordship can pass this order, my lord, then from the state of protest petition that can be started, my lord.
How can it be? Once the cognizance taken.
see once the Post Office Act, where obscene telephone calls are included. Which will, 294 might not come, but Post Office Act 1898 shows any obscene words sent by post, of course, that telephone was not there, 1898.
This may I humbly submit, Lordship, in respect of these, that whether these words are obscene. Lordship, these words are not at all obscene. These are slang or abusive words. Now, there's a difference between abusive and slang, obscenity. In fact, Supreme Court in NS Madan Gopal has clarified this context, Lordship.
That's right, that is also correct.
Yes,
That
this is
obscenity
not
something different.
Yes, these are
There has to be a
abusive words.
sin.
Yes,
That is why obscene.
yes.
There has to be a sin. There's action to be seen. To read this is, in fact, one of the cases we have considered that aspect. But abusing somebody by using derivative word, that will not be an obscene sin. Again, 294 is very clear.
Yes. In fact, Lordship, Kerala High Court has set aside an order
Does
proceeding.
any obscene act in public place? Signs, recites, or utters any obscene song, ballad, or word.
Sings, recites, or
Recites,
utters.
utters any obscene song, ballad, or words in or near any public place.
No, his case will come within recites. Utters. Any obscene songs, it will not come, ballad or
That
words.
is any obscene song.
Hmm.
That will not come. The language which has been in the affair
Hmm.
is something else. It's an abusive.
Abusive words.
Abusive.
Anyway, Mr. Bora,
Lordship will just see section 20 of Post Office Act, if it comes, I mean, and whether it is a cognizable offense, I have not found out.
Post Office Act.
Post Office Act 1898. This is anything indecent.
Now, Post Office Act 2023 has also come.
I don't know. This is 1898 and see.
I think
And it is repeat.
2023 is there. Just a minute. We'll just see.
Oh, then it is repeated.
Hold it. 2023 দেখো না 2023 post office থেকে।
There will be corresponding provisions. Indecent. Anything.
The New Act doesn't have the penalties.
They don't have. Even that indecent thing is not.
Nothing there.
Earlier one had. Because Indian Telegraph Act came, so perhaps because of that, it is not included here.
There's all the offenses, whatever was there under the 1890 Act
Hmm.
has been removed from this 2023 Act.
Yes, all the offenses are there.
So it will not come.
So, 10 of course.
Remove all the penalties
Huh.
relating to misconduct, fraud, and theft.
Hmm.
So, Ms. Zahan, that will not come.
That will not. Watch it.
Okay, we'll pass an order.
August.
Okay.
Wait, please, wait. In this case, my lord, scan copy of the PIC case number 686 2024 was called for, my lord.
It's here. It has come. It is there in the record.
Yes, okay. Did you see, my lord?
Mr. Gogoi, what's the matter about?
Matter, my lord, the petitioner has challenged seeking quashing of the my lord, proceeding initiated against 138 Negotiable Instrument Act. Actually, what happened was SEC, that was, my lord, kept as a security sake with the father of the complainant against another debt, my lord. Lordship come to page 21, this is the head note, where the SEC is, number of the SEC is mentioned, my lord. Subsequently, petitioner has paid the amount, and his son, my lord, thereafter, when his son initiated this, my lord, proceeding, my lord, against that SEC, my lord, using that SEC. And against that proceeding, my lord, misuse of SEC, my lord, the petitioner has filed an FIR, lodged an FIR before the officer in charge Goromari Police Station, my lord. That is at page 29, my lord. In that case, my lord, charge sheet has been submitted. So record was called for. Initially, my lord,
Yes, you want to go through the records? The police have filed the search sheet. The cognizance was also taken on 19th of July against the respondents.
Regarding that, your lordship, I have no any instruction, your lordship.
That's what the.
Maybe
record
in the
reveals.
record, your lord.
That the record reveals.
In this case, your lordship, I am appearing for respondent number 2,
The complainant.
complaint.
Will not exercise our power under 480. But
Lordship,
we'll
may
remand the matter back to
remand
the
it back
learned,
with
magistrate
observation that
because it's in 138th proceeding. And you are the accused in that matter.
ma'am,
You will place all these matters before the learned magistrate,
that may be
along with
possible.
these records that FIR was lodged against him wherein the police found.
Ma'am.
Because police have already seized that agreement between you and the informant.
Yeah, madam. That I
the
know that.
complainant. So as per that, and the person in the affair, what we have seen, the person from whom the complainant purchased the land, he have given evidence.
Right.
The thing that of the total sale amount, he has paid the amount to him, to Sri Lanka. And that is the reason why the complainant has handed over the agreement to the present petitioner. But at that point of time, he could not return the blank check as he could not trace it before. So it was not available with him at that point of time. He said as soon as it is found, it will be returned. But later on, he was started saying on being inquired that when this petitioner is to ask him, they had a good relation. In fact, they used to sit together in a particular shop. And then the petitioner here is a government employee. So it was there, and then he said those are in 161, of course, but anyway, to that extent, that is why the IO found that the materials, whatever been stated in the FIR, lost by the petitioner, correct.
But what is in the case diary, your lordship, I don't know. But here in the respondent number 2, he is the son of the Nabbas Ali, your lordship. And they said that the check was given to the father, and subsequently the same check was used by the respondent number 2. So everything they will get chance, your lordship, before the court below.
That is why we are not interfering.
Yes.
Lordship, may I go to observation?
I think there is no need to issue any observation.
Just a minute, let us see the records relating to the 138 proceeding. What is the stage of the NI case?
I think
Already PW.
already PW one is examined, my lord. Last.
Heard Mr. J.C. Gogoi, learned counsel appearing for the petition. And Mr. B. Sharma, learned additional public prosecutor, Assam for the state respondent number 1. Also heard Mr. A.M. Khan, learned counsel for the respondent number 2. The respondent number 2, as a complainant, filed a petition under section 138 of the NI Act, 1981, before the Iran Chief Judicial Magistrate Kualpara on 07/09/2023. Being NI case number 28 of 2023. Alleging that the check amounting to rupees 10 lakhs, 10,000,000 issued by the petitioner on 08/01/2021 alleging that the petitioner on 08/01/2021 borrowed an amount of rupees 10 lakh from him and when the complainant slash respondent number 2 demanded the said amount from the petitioner slash accused person. The petitioner on 05/08/2023 gave him a check of rupees 10 lakh in discharge of the white check number 745835. Bank to Peter Patel. We did. Issued in a bank, State Bank of India. Soigam branch. Was discharge of the said loan amount. When the complainant respondent number 2 presented a said check for its liquidation through the Drawee Bank, State Bank of India, Dhukdhara branch, from the account of the petitioner bearing account number 116720491133. The said amount was dishonored. 8/8/2020. and it was accordingly informed to the complainant, respondent number 2 on 08/02/2023 itself. As such, the complainant respondent number 2 to his counsel on 16/08/2023 sent legal notice to the petitioner under section 138 of the NI Act. And in spite of the notice received by the petitioner, he did not reply.
The petitioner replied on 18/9/2023, page 24. Man.
Subsequently, as such, the complainant on 07/09/2023 filed the said application under section 138 of the NI Act against the petitioner. With a prayer, claiming 20% of the total amount as interim relief. The Planet Chisholm Golpara, after recording the evidence of the complainant and 2 other witnesses, after recording initial deposition evidence. By order dated 7/9/2023. To cognizance of the offence under section 138 of the NI Act. Natural summon to the petitioner. They said NI case number 28/2023 prepared by the respondent number 2. The petitioner on 4/12/2023 was allowed to go on bail by the London Chisholm Golpara in the said NI case number. And in the meanwhile, the complainant submitted all the relevant documents for the requirements. In the meanwhile, the petitioner filed this criminal petition on 12/01/2024. Praying amongst others, challenging the order dated 07/09/2023, whereby landed CGM Golpara took cognizance of the offences under section 138 of the NI Act against him, the complaint case number CR, then we get NI case number 28/2023. And all the consequential action. It's a different cost, and all the consequential action. And to stay the further proceeding, with her intending there to stay the further proceeding of sale such and such. Such prayer challenging the order dated such 7/9/2020 against the said CR case number such and such, CRNI case is on the ground that the petitioner, because of certain need, though took an amount of rupees 3,00,00,000 from the what my request. Response number 2 request. Yes. Took an amount of from the father of the response number 2, Abbas Ali, and in that regard, on hand note was executed on 26/02/2022 between the witnesses. Wherein it was clearly mentioned that a blank check bearing check number 745835 of SBI Gumi branch as the liability was given to the father of the respondent number 2 on condition that the same shall be returned on the day when the petitioner pays the loan amount. Along with the written hand note. The further condition therein that no transaction can be made through the said check. It is stated by the petitioner that on 27/08/2022, he repaid the said loan amount to the father of the respondent number 2, Abbas Ali. And on the same day, respondent number 2's father returned the said written hand note to the petitioner, but did not return the said check number such and such. Stating that said check was lost somewhere and could not be traced. It is alleged by the petitioner that instead of returning the said check number 745835 issued by the petitioner to the father of the issued by the petitioner to the father of the complainant respondent number 2, it is the complainant respondent number 2, such and such, son of Ambedkar, fraudulently and dissonantly presented the said check in his bank account the SBI Dhara branch in 5/8/2023. And after dishonoring of the said check, I will tell you, when the said check was dishonored, the complainant respondent number 2 initiated the said proceeding against the petitioner, demanding a payment of rupees 10 lakh from him. It is also submitted by the petitioner that though he immediately contacted the father of the respondent number 2 and complainant's father assured him to resolve the matter amicably. But instead of that, the complainant respondent number 2 did not solve the matter in spite of repeated requests. Having no alternative, the petitioner on 16/9/2023 lodged an FIR before the officer Gorimari Police Station, stating the above facts and the misuse of the said blank check number such and such issued by him to the father of the petitioner. Misuse by such blank check number by the petitioner, the complainant respondent number 2 that was given by the petitioner to the father of the said complainant. Pursuant to his said FIR dated 16/9/2023, Gorimari PS case number 89/2023 under section 420/406/384/506 IPC was registered against the petitioner of the complainant, the FIR of the petitioner. And since the complainant respondent number 2 miserably failed before the learned trial magistrate to prove that the petitioner took loan from him and for the reason stated above, it is submitted by the petitioner that the said proceeding under section 138, the NI Act pending against him before the London Chief Judicial Magistrate Walpara being seared, put in bracket NI case number 28/2023. So this set aside and first. We'll come back. But to me, I do.
Highly agree.
Item number 1.
আমি আসলে
Yes, Mr. Sharma.
My lord, the marriage between the parties was solemnized in
Now that
the-
we have seen.
my
Yes.
lord, 2015
Yes.
and
We are
2016.
not on that. Why you are here today?
My lord,
What was the
because
urgency?
because
of this?
urgency is, my lord, the case is fixed again on 27th of, my lord,
Yes.
this month.
Hmm.
And the maintenance
Hmm.
which has been granted,
Hmm.
my lord, that has to be paid
Hmm.
on the next date fixed, my lord. That is
Right.
why, my lord, urgency is there. Lordship may kindly see the impugned order. While, my lord, I am on date of marriage and date of, my lord, living separately, that is, my lord, 2017, the agreed person has been living separately.
See,
And
Mr. Sharma.
more than 5 years, my lord.
Yes, one more. This matter was while issuing notice.
My lord. This is not a case of domestic violence at all, my lord.
Now, this petition when you file, you have filed with an interim prayer.
My lord.
The court, while issuing notice,
My lord.
did not pass any interim order.
My lord,
and also did not say anything in that order. That interim order shall be considered only after service of notice on the sole respondent, the aggrieved person. Now, when that order is not before us, if we have to act upon the interim order now, it will be amounts to review.
My lord,
And we cannot review that order at this stage.
my lord, this is not amount to review as per
See,
my humble
clearly,
submission, my
if
lord,
you want-
because, my lord,
This is the order, I can read it.
the considering the urgency, my
No,
lord,
no,
the
that's
honorable court in while issuing the notice directed to take dusty service.
Fine.
We have taken the dusty
The
service.
court did not pass any order with regard to that extent that the interim prayer regarding the payment of interim maintenance of rupees 3,000, which was the petitioner has paid for stay, will be considered after service of notice on the sole respondent, the aggrieved party.
That
There
is
is
not,
no finding.
that is not reflected in the
Not
order.
right.
But
And that's why
it
at
is-
this stage,
That's true, my lord, that's not
when it is not
reflected in the
before us,
order.
why
But
should we at this
considering,
stage consider that matter?
but considering the, my lord, urgency, my lord, the honorable court while
See,
issuing the
basically,
notice,
we
my
have
lord, that
seen,
has
there
been.
was a we found that considering entire aspect, the learned JMFC passed that order.
Hello.
And also there was a ground, the same ground which you are making a submission here. In fact, the order of 3,000 was paid long back.
Right.
And you filed an objection before the magistrate.
Yes, ma'am.
Saying that the matter is pending before the family court regarding the separation and this thing. And the matter is pending before the conciliation. The learned magistrate did not insist on that order initially because of that. That order of payment of 3,000 was passed when? On 5th of August 2023.
Yes.
But thereafter you filed application. The matter was stayed. Ultimately, when the conciliation failed, in December 2023, registered reiterated that petition of staying has been rejected.
On 16 December.
16 December
2023.
After 2023, you have filed this petition on when?
My lord, it was
19th
moved
of
on
March
21/3/2024.
19th of March, the matter was taken up on 28th of March. Who did not pass any order?
My lord, my lord, my lord, project, my lord, on 21/3/24, while the matter was, my lord, listed and notice was issued, considering the, my lord, interim pair, the honorable court fixed the matter on 28, my lord, within a week, my lord, because, my lord, because of the interim pair, my lord. That has not been reflected. Admittedly, my lord, that has been reflected in the order, my lord.
On
But
21st of March, on the request of the land council for the petitioner, list this matter on 28. It was listed on 28.
my lord,
On
that has
28th,
not been
notice of
reflected.
notice.
That's true, my lord. But considering the, my lord, prayer made in the petition, my lord, that has been fixed within a week and that dusty service was directed to be taken. Accordingly, dusty service was taken. My lord, in spite of receiving notice, my lord, the respondent herein did not appear. In fact, my lord, matter was remanded to the local adlat. My lord, in spite of receiving the notation from the local adlat, they did not appear in the local adlat. In the, my lord, divorce case, my lord, it is pending, my lord. Why, my lord, I have here, my lord, because, my lord, this domestic violence, if your lordship goes by the definition of the domestic violence, no commission is, my lord, reflected in this petition filed by the my lord, respondent in the domestic violence petition. Nothing has been reflected. And she filed this petition after, my lord, lapse of more than 5 years, my lord. Is it, my lord, the case of domestic violence? No, undoubtedly, my lord, so far the, my lord, divorce case is concerned, since conciliation failed, we, my lord, ready to take back her, my lord, the petitioner herein is the sole person of entire family, my lord. He is alone, my lord. And she, my lord, requested her to, my lord, take back.
Mr. Sharma. I
That
don't
has been
think so.
failed. And
Will
it is
not, because
contesting. my lord.
otherwise the court will definitely pass the order in the interim. There was an interim prayer.
My lord,
There
what
was
is
we
the,
have
my
made-
lord, lordship may kindly see on the basis of, my lord, observation made in the, while passing the order of maintenance, lordship may kindly see page 81. Only, my lord, observation why, my lord, this maintenance has been granted. In order to, my lord, prevent restitution of the aggrieved person during pendency of the instant case, I am of the opinion that she is entitled to receive monthly interim maintenance from the respondent.
That's as per
No,
definitely. wife
my
is
lord,
entitled.
if she, my lord, maintain herself for more than 5 years, and during pendency, what is the urgency for, my lord, granting the maintenance, my lord?
We are not interested for a husband and wife fighting, and if you are a responsible husband, you have to pay. And
My lord,
since the
the
court
peti-
did not pass any order earlier, we are not inclined to pass that order at
My
this
lord,
stage.
lordship may kindly consider, my lord, the petitioner who is a sole person, and he is, my lord, ailing person, my lord. I have submitted all the medical documents before the trial court, my lord. That has not been taken into consideration, my lord. He is a
How much
psychiatric
you are
patient,
paying to your child?
my lord.
How much maintenance you are paying to your child?
No, my lord, my lord, they did not, my lord, file anything, my lord, prior to that, prior to this.
You are a
petition.
father like that? You
My
have
lord-
your own son, you are not looking after him?
My lord, the respondent did not allow the, my lord, petitioner to, my lord, meet, my
Not
lord,
Mr.
the
Disarma
child
Council
from
applying for
the
the petition.
date of
And,
the.
we are not inclined at this stage. Otherwise, the court would have passed that order on the initial stage itself.
My lord, my humble submission, my lord, that may be kept in abeyance for the time being, my
We
lord.
are not passing any order. It is there, that's, we're placing it before the Lodgima court for the report of service of notice and the sole respondent. That's all.
Notice, my lord, I have filed
You have filed the
affidavit, I have filed. my lord.
that we have seen, but there was also registered post to that count. Lord Mr. D.K. Sharma, counsel appearing for the petition. There was the order dated 28/03/2024, passed earlier in this past. Matter be placed before the Lodgima court. Pursuant to the order of the court, 28/03/2024, the petitioner submitted that steps on the sole respondent took was taken earlier by justice service as well as by registered courts. However, full stop. In that regard, petitioner has filed an affidavit on 23/09/2024 regarding such justice service in the sole respondent. The petitioner has also taken steps on the sole respondent by registered post. Office note dated 03/04/2024 reflects that steps on the same sole respondent was taken, was sent by registered post on 03/04/2024. From the affidavit filed by the petitioner and the receipt of the justice service by the sole respondent, it is seen that such service was made on the sole respondent in absence of any witness, as the receipt notice by the sole respondent doesn't carry the signature of any witness in whose presence such notice has been served by the petitioner on the sole respondent. In view of the matter be placed before the learned lodging of court for its report as to whether notice by registered court has been served on the sole respondent or not. Further, the petitioner is allowed to take fresh steps for service of notice on the sole respondent by dusty oblique personnel service to be routed to the registry of this court, which shall be served on the sole respondent, obtaining her signature with date in presence of one or more witnesses, serving a copy of this criminal petition along with the annexes that happened there. Thereafter, petitioner shall file an affidavit for completion of such dusty oblique person service. The sole respondent directly. List on 11th of September.
May take place, my lord. On that day, my lord, after service of notice, my lord, the interim order may.
That is not the issue here.
My lord,
File an application. File an
That,
appropriate
that observation only.
We are not making that observation. See, that will amount a review. File appropriate application.
Well, since there is prayer in the petition for interim.
Mr. Sharma,
My
file an appropriate application. It was
My
not
lord,
considered earlier that
my
will
lord,
amount a review.
that may pray, my lord, that observation for filing an appropriate application.
There is not required. That is not required.
Which shall be considered on the next date fixed.
File your application first.
My lord, if the application is filed, my lord, that observation may appear, my lord.
First file. Yes.
May I please your lordship? Lordship, I am appearing for the respondent number 2 on behalf of Mr. B. Pathak. My lord, we have filed our Vakalatnama today. My lord, we need 1 week to pursue the record, my lord. Matter may be listed on next week itself, my lord, for in the admission column.
What's your good name?
M. Sharma.
But Mr. M. Agarwala,
My lord.
counsel for the petitioner. And Mr. B. Sharma, and additional public prosecutor for the state respondent number 1. Also heard Mr. M. Sharma, Land Council, presented appearance on behalf of the respondent number 2. Mr. Sharma submitted that he, along with his senior, Mr. B, has filed a alert number today for the respondent number 2. In view of the above, the service of notice is complete on the respondent number. Place this matter for admission again. The registry has already received the reports of the NI case number 90/2020 from the Court of Learned CZM, Nalbari. Place this matter for admission on eleventh. Next.
Criminal revision petition against the criminal appellate order. The petitioner is in jail.
Against conviction. Go on, right?
409.
Huh?
409. No.
Bail.
Bail from affairs.
Standing counsel.
He is. University FIR is informant. Secretary.
Never. No.
Yes, what's your prayer here?
Also, the prayer is for.
Where is the illegality, Mr. Guru?
Lordship, there is no, there is firstly that 197 being an employee of the Assam Agriculture University. There was no 197, section 197 was not followed. And secondly, there is no, there is no link, and two people were set free, but out of all these people, but all those questions, and no, there is no connection between the teacher, I mean, the money entering into the account and that person, because he's not a drawing and disbursing authority or something like that.
Then
And how come money has come into it that has not been very proved in a beyond reasonable doubt? He was not even entrusted with the money.
কপি নিদিয়ে কপি কিয় নিদিয়ে নতুন মেটাৰ 22 নাপাওঁ কপি নাই
Take your seats. Take your. Ms. Jahan, have you gone through the records?
Yes.
You have gone through the record.
Look, I have gone through the judgment. Of course, the disposition of the parties. Now, what I find is that he was the bench assist, he was the bill assistant.
He used
He
to
was-
prepare the bills.
So he had the dominion over the property as a public servant. And thereafter, it was during the leave that the entire anomaly came into picture.
But no, why, I think you should go to the record.
Lordship.
Because of the deposition.
Records have come, records.
Yes,
have
it's come, it has come.
Uh-huh.
Go to the deposition, there is reason. He was not the only person to prepare the bill.
He in fact wanted, there has to be some other persons.
There are 7-8% that goes to the process to the highest level, then it comes back again after the final assessment. So thereafter, these DDO concerned drawing and disbursing officer is to disburse those amounts to the respective accounts. So it has processed too many.
Yes, it has to.
So it does go through because see, we are not in a service matter. Service matter will be different, but here it is beyond reasonable doubt. So you go through the record and then tell us. You go to the record, take your own time when, give us a date. by that
Today,
time.
it has come up for admission. Lordship can dispose it of in admission stage. itself.
Yes, yes.
And bail as
Allow
far
you
as
to go
bail.
to the record and make submission.
As far as bail is concerned, Lordship, he has already retired from service. In that petitioner.
Petitioner has retired, no problem. There are other people whose amount has been deducted at 3 lakhs each. They have also not been paid. Because of the amount is around 38 lakhs. So from some other employees of the Assam Agriculture University, each rupees 3 lakhs was deducted in that particular channel who are involved. To recover that amount. So they have not.
That
also
point
been paid.
was in fact taken before the trial court that there are more people involved, but then trial court rejected.
That is why you should go through the record.
Lordship.
And then you tell us, because it is a huge record.
Lordship can take it up next week. I'll go through.
Next week or year after, we'll have it sometimes in the week commencing from 16 September.
16 September, Lordship.
The first 2 weeks, board is full. We'll take up.
Lordship.
We'll take up, what we'll do. Admit this matter for hearing. Hardly here. SS Law Council for
Legally
council for the petitioner and Ms. S. Saman, Additional Public Prosecutor for the state. List on 19th.
19th.
Meanwhile, you go to the
Lordship.
for hearing. Mr. Boro, make a mention in the morning. When the matter will be listed, we'll take up your matter. Like we shall. I don't think it. Orders can you? It will be any orders can you get.
For order, item number 12.
My lord, may it
Why it
please,
has come for orders today?
my lord, I could not see the file. It's a transferred brief, my lord. I have not seen whether the steps were even also taken. My lord may give us some time, my lord. We will take a fresh step because other side has not appeared, I believe.
Just a minute. Earlier set of councils are not appearing.
No, it has been transferred to me, my lord. And I have not gone through yet. Even could not see the file because it was there in the lordships besides, my lord. So. Lordship may give us time. If necessary, we'll take a steps, my lord. And I am told there is an interim order that may continue.
Take a seat, Mr. Samo. What happened in the family court?
We got the divorce. No. No, these are all the,
Anything regard to alimony or anything?
nothing.
Some amount?
She did not appear there. But initially she appeared, thereafter she left appearing. She filed a transfer petition for transferring of the
No,
case.
it was rejected.
That was rejected by this one. Well, these are all the cases, Miller, for to harass this person.
Heard Mr. A. Sumo, learned counsel appearing for the petition. Register shall reflect the name of, oh, your name is there. Peruse the office notes. Petitioner is Director to take press steps for service of notice on the sole respondent in the following address. Rupamoni Kolita. Page number. Additional affidavit. Additional affidavit এখন তাতে চাই ল'ব নামটো ৱাইফটো নিলিখিবা খালি ডটাৰক লিখিবা
Thereafter, even there are several rounds of litigation. In fact, they approached the honorable court also for allowing them to get implemented in the present proceedings. Thereafter, the honorable court disposed of our proceedings, allowing us to file appropriate application before the learned court below, and thereafter we were allowed to participate in that particular proceedings. And accordingly, we participated in the proceedings under section 301 of the CRPC. And the new incumbents were thereafter issued summons. Thereafter, the new incumbents, they have come here for quashing of the proceedings. That is how the proceedings are. And the present, the implement applications which we have filed, earlier on the previous occasions, the honorable court had opined that the entire matter, the implement applications as well as the entire matter can be heard together. That is how the implement applications have also not been decided. And the award has also not been implemented. Facts are like that.
You are the beneficiary.
Lordship.
You are the beneficiary.
We are the beneficiaries of the beneficiaries.
Notice in the implement petition has not been issued. Notice had not been issued because they have put the matters to be heard together.
In fact, no, objections has already been filed by the petitioners. Yes, notice, otherwise they have received, management has already filed the objection also against the implement applications.
What is the objection? Who is appearing for ONGC?
ONGC, Mr. D. Soikia appears.
Learned AG?
Yes.
What is the ground for objection?
Several grounds. One of the grounds they have taken is that these particular petition applicants, they have already been regularized or sorry, they are not part of that, their names are not included there. That is one of the grounds. Then also another ground taken up by them, that the complaint is itself not maintainable as it is the present petitioners. They were not party there. These are amongst the several grounds taken up. And also the cognizance has not been taken up in the proper manner. It's proper.
There is some dispute that some 37 are not, are you within that 37? Because there is
No,
some
Lordship,
observation.
that is what they say here, but the records will reveal that these persons, in fact, the appropriate government, that is the Labour Commissioner, has initiated the complaint as per the provisions of the Industrial Dispute Act on our behalf under Section 29. And just because our names appear there, and since we and after being satisfied that these are the persons who have been left out, they have initiated the complaint on our behalf. And as regards
Listen,
these and these are disputed facts. Whether the trial court below will examine these facts, or the Honorable High Court in the petition under 482 will go into these facts. And in fact, the fact remains that if the entire documents are produced, the court's orders, etc., these are the persons who have been left out. The award has not been complied with regard to these present petitioners. In fact, there are others also.
This,
Some-
let us have it on some day.
Yes, yes. Because the other party is also not present, so it will not be fair on my part.
19th September.
Can it be on 18th?
18 is a working.
Lordship,
19 is-
17, can it be on 17th?
That's a Vishwakarma Puja day, that's why.
Sorry. Oh, 19, yes, 19.
Yes, you matter. Have you gone through the records? Because here what we found, that those notification clearly mentioned that those both the person, the concerned executive magistrate as well as the PSO concerned, were on duties.
They were assigned duty in that place.
And but the London magistrate proceeded in the matter, holding the that they were not on duty.
Acha. Lordship wanted us to bring some instruction perhaps, or what? I don't know.
No,
My learned friend said that I have some instruction. That was misunderstanding.
That's true.
Goes. There is no instruction as such in this case.
no, we just want to hear other side.
Huh.
Because she earlier pointed out, Ms. Das was there. She pointed out two things. She did not go through the record, but there's a finding here. came to the finding that the present petitioner not serving were not on official duty. That is what. That's why the magistrate district special session thus proceeded with the matter. But the record reveals at the time of filing of the application itself, the court, the petitioner, along with the government notification and the order of their service, it's filed that they we have thus checked the applications of the.
No, it is no doubt, it's not disputed that they were assigned the duties there. But then the allegation will never come within the discharge of official duty or in purported discharge. Because what it is said in the FIR is that they had beaten them up, showed pistol, looted the articles. This will not come within official duty.
Those things are not there.
Lordship will see the FIR, it's there.
That's what we have seen.
Lordship.
In fact, going to the records on
Huh.
the day, how many people first? Was the informant?
Anwar Hussain.
Anwar Hussain.
He's also associated with some political party.
Yes, so that time then they are the ruling party.
Two-wheelers রখাইছে, four-wheelers নহয়। তেতিয়াহ'লে ই কিহত আহি আছিলে? ক'ত লিখা আছে? Four-wheeler হ'ব পাৰে। সেইটোতো বাৰু আহিছে, সিও চাগে four-wheeler আহিছে। মটৰচাইকেল বুলি কিয় লিখিছে? বাই মটৰচাইকেল। মানে অসমীয়াখনত আছে।
If you read the FIR,
Lordship. Motorcycle সন্মুখত। Because he said that they overtook him and then two persons coming from behind in a Maruti car in a high speed prevented by overtaking him and started to assault me in my face. They injured kicking me. Dire consequences, showed a pistol. Then they
say
looted.
that is in the Assamese version is like this. আজি সন্ধিয়া 5:30 মান বজাত মই গৌৰীপুৰৰ অৱস্থিত ব্লক কংগ্ৰেছৰ কাৰ্যালয়ৰ পৰা নিজ বাসভৱন মাটিয়া বগত আহি থকা অৱস্থাত ঠিক মাটিয়া বগ মূৰত পিছফালৰ পৰা দ্ৰুতবেগেৰে মাৰুতি কাৰেৰে আহি দুজন ব্যক্তিয়ে মোৰ মটৰচাইকেলৰ সন্মুখত আগভেটা দি উগ্ৰপন্থীৰ দৰে মোক গালে মুখে হঠাৎ মাৰধৰ আৰম্ভ কৰি এনেতে মোক প্ৰাণে মাৰাৰ বাবে পিষ্টল দি ভাবুকি প্ৰদৰ্শনেৰে লাঠি গুৰি মাৰি মোক জখম কৰে। ঠিক সেই মুহূৰ্ততে নবী হুছেইন নামৰ আমাৰ দলীয় কৰ্মীজনো অনুৰূপ ব্যৱহাৰ কৰাত ওচৰতে উপস্থিত থকা দোকানদাৰ তথা পথচাৰী ৰাইজে ঘটনাস্থলীত উপস্থিত হৈ প্ৰথমতে আমাৰ প্ৰাণ ৰক্ষা কৰে। যদিও মোৰ গলত পিন্ধা 2 ভৰি ওজনৰ সোণৰ চেইনডাল উক্ত মাৰুতি ভেনৰ দুষ্কৰ্যকাৰীয়ে ছিনতাই কৰি নিয়ে আৰু ঘটনাস্থলৰ পৰা পলাই যায়। পিছদিনা জানিব পাৰিলে যে উক্ত মাৰুতি কাৰৰ চালকজন such and such Dulmari, Dhuburi Executive Magistrate, After Lord Patakan Theore, PSO. Gotike Mohandas such. Now, the medical report says the incident occurred on 25/1/2000. It was incident occurred on
2006.
same day. Same date in the evening around 5:30, he said. And medical examination was done at 9:30 p.m.
Same day.
Same day. Injury report is a fresh aberration over the right cheek and also over the right upper eyebrows caused by blunt object. Simple injury. There is nothing else.
He in fact said they hit him on his face.
Hmm.
So chin and the
No, there is a judgment by Justice Gogoi while he was regarding 197. So here probably the prosecution sanction was not obtained.
not obtained.
That's the reason.
It is not required in the face of the
That's
case.
what-
of
That is the
course.
reason. That is why I'm saying. In that judgment, these things were considered
Ah.
where the prosecution sanction is required.
No, Matajok Dubey, Lordship knows.
Anything, any act in the official capacity. Now, whether this part is in the official capacity, this act alleged by the informant, that has to be seen.
That has to be seen. In fact, Matajok Dubey and all those decisions says that if it is integral part of his duty,
So, in fact, on last occasion, Miss Pachaji was there. She placed the reliance on the judgment of the apex court.
Yes, Lordship.
In the case of, just giving it, it's an old case.
এটা তো লিভিং কেস এটা সেক্রেটারি কেস না মাতাজো জবের কেস
It's a case of 2006, in fact,
Yes, runs
Rakesh Kumar Mishra
6
versus State of Bihar and others.
7.
Therein, the relevant paragraphs 6 and 13.
Yes.
Wherein the Honorable Apex Court, that's it.
মাতাজো জবে এটা তো লিভিং কেস নাকি থ্যাংক ইউ পসিবল না মাতাজো জবে
There you'll see paragraph 13, 2006, 1 SCC 557.
Gotcha.
Para 6, Ms. Bhachaji relied on first, right?
Yes, Lordship.
Para 6, it's a big paragraph anyway.
Paragraph 6 in middle part. If in doing his official duty, he acted in excess of his
Excess of,
excess of his duty, but
there is a reasonable connection between the act and the performance of the official duty, the access will not be a sufficient ground to be deprived the public servant from that protection. That line was.
That exercise, this has been settled by Supreme Court, Shankara Moitra. That is also a leading case on this. But excess, they can go little beyond what is provided, but then there has to be again an integral connection.
Again, para 13, if you come.
Yes. In so far fact, therefore, it is a prima facie to found that an act or omission for which the accused was charged had reasonable connection with discharge of his duty, then it must be held to be official, to which applicability of section 197 of the court cannot be disputed. It was clear that Lordship, my duty has been started from 5:30, Lordship. From the Lordship. That's not it.
In fact, there was no flying of two-wheelers from 5 p.m.
to 6 a.m.
to 6 a.m. on the next day. And then this incident occurred at 5:30, as per the information given by the informant.
Yes, 5:30 is written in the evening. As far as those things are concerned, well, it is beyond.
The thing is, now whether the sanction under 197 will be required.
Required.
Prima facie, both the petitioners had their unofficial duty. But the actions taken by them beyond their official duty.
Beyond their official. And even excesses cannot, Lordship can bring it within the duty. Because Shankara Moitra, Lordship will remember Matajok Dobe, what happened? The income tax officials, they went in search of some papers in an office. There were security guards. Security guards were not allowing him to enter. And then they tied the security guards. So that, and they entered. And that in that circumstances, Supreme Court said, yes, sanction is required. Because it is their duty to search and get the papers. And otherwise the papers will get lost. So in those circumstances, I have written all the facts in my diary. Shankara Moitra, what happened? The husband was beaten to death by police while the husband was distributing some food in some center. And then police came and hit the husband. Husband died. And then a victim was taken to hospital. Later on, the husband died. Then it is said, no, it was required because he was giving, he was not letting the police to work. So in those circumstances, there are so many cases like that. In fact, excesses, State of Orissa versus Ganesh Chandra, it is said, in doing official duty, if he acts in excess of his duty, but there is a reasonable connection between act and performance of duty, the excess will not be a ground.
So that is why also in para 13 here is the same finding.
No, had that been a case that he was crossing at that hour with his motorcycle and they told him to stop, he did not stop, then they fired. In that case, then it will come within official duty and it will be required. But here is a case, he had beaten him up. And then, there are injuries. I don't think so. This is a case which will come within these parameters. Threatening him with dire consequences, showing him pistol. There is nothing in the FIR stating that he was trying to flee away. There is nothing in the FIR that he was trying to flee and we had to do this. Or FIR, it will not be there, but in the other the things, it should come. In the records, Lordship can find it out. I can see. Lordship can take it up on Monday, Tuesday. I'll see the records.
Tuesday.
If there are any witness saying that he tried to flee,
Tuesday.
I'll see the records.
Yes. Go through.
Lordship.
And then we'll have it until
Tuesday.
record to be.
Tuesday.
But Miss Das on that day also was asking for a copy. She didn't have a copy.
I didn't have the copy. In fact, I'm taking it from him.
Go to.
Your Lordship. Prosecution sanction is a tricky subject, of course.
It's
It's a,
depends.
it's a
No, it
tricky-
depends. Facts depends from.
depends on facts.
That's
If
how
I
we-
can get somewhere, some witness saying that he was trying to flee away, then it can be a case. They stopped him and they assaulted him. This is not within his official duty.
Only thing is that it was only from 5 to 6 though, and the incident occurred at 5:30.
And that
That
is
is-
okay.
Let us see.
They could have apprehended him, but not
They
beating
could have
him up.
stopped him and, from plying the scooter.
Uh-huh.
That is.
Yes. Got you.
Okay, we'll have it on Tuesday.
Tuesday.
Next one, second. Quarter hearing. In the meanwhile, I must. Yes, Mr. Bush, any matter?
Yes, ma'am. Item 21.
He really couldn't. Didn't. Mr. Bush, there is another matter, just a- if there is any, if there is no counsel, will take up your matter. No.
21.
We don't think so. We'll take any other matters. Only 21 will take it.
May it please your lord. My lord, this is a 482 application, my lord. The complainant, the opposite party, the petitioner is the headmaster of the school, and the opposite party here, my lord, she is the peon, my lord. What happened, my lord? Due to some allegation, school inspector transferred her. Then she refused to accept the transfer order. And with that, my lord, she thought that the principal, that is the petitioner, engineered her transfer. She quarreled with the headmaster, and cross cases were filed. Now, my lord, the case filed by the petitioner, against which the opposite party approached this honorable court, and that petition was dismissed. Quashing petition filed by the opposite party was dismissed. Here, my lord, but in this case, my lord, what happened? She filed the affair alleging some allegation against the petitioner, which was ultimately culminated to final report. The police has given the final report. Thereafter, she filed the Naraji petition.
Where is the
That was allowed. And my lord, against the complaint case, I have approached this honorable court.
Where is that Naraji petition?
My lord, Naraji petition is at page 44, my lord. This is the translated copy, and 45 is the vernacular.
Mr. Datta.
My lord.
The judgment of the apex court. In fact, that is not also in the, sometimes in the first half of this year. fact, earlier, this could also passed in judgment, we don't know whether it has been reported or not. This Naraji petition, the protest petition, the judgment is very clear. Now, if you come to page 45,
My lord, our High Court judgment is there. Honorable Justice Bhaipes Gowda, my lord, judgment, my lord. Is still holding the field, my lord.
there it is required in the protest petition. It is not that, in fact, what had happened, there earlier a complaint petition was filed. The issue is like this. Complaint petition was filed. And on the basis of that complaint petition, learned magistrate directed to make an inquiry to submit the report in the final form. And ultimately, the police submitted the final report. So necessarily notice was issued. In that case, the complainant thereafter on receiving of notice from the magistrate submitted an application. Protest petition was filed saying that I have already filed complaint petition. And this effort should not be considered. I am objecting to it. The learned magistrate proceeded with the matter. And then the party agreed, approached the High Court. It was considered rightly assessed. The matter went up to the apex court, wherein the apex court has come to the finding they know that if it is a protest petition, the Ms. Jahan was aware that case. Somehow we are not getting it. That in the protest petition, it is the duty on the person, the Naraji, whoever is filing it, has to lay down the reasons, same complaint, but that grounds of complaint has to be there in the Naraji petition. With that regard to in considering those aspects, this court passed the judgment. I don't know if it was reported or not. But regarding one, Gautam Sudhiri was asking me about my death judgment, but I don't know whether it has been reported or not. He was aware of that. So maybe that is why asking. Those judgments in the apex could have considered those aspects. So in a complaint petition, normally, that the complainant is required, that is in an Naraji petition, had to specifically say, what is the complaint that has not been looked into by the police. That is what is required. Just mere mailing or 4-line protest petition or that I have an objection and I'm not satisfied with the report. That is not taken. Even on that basis, of course, unless those things are there, because after the protest petition, what happened? The magistrate takes, it's a proceeding under 200 now. It's a complaint petition. Under that way, it will proceed. So for that reason, these grounds are necessary. Earlier complaint petition or earlier FIR, wherever goes, it will start as a new proceeding. So that is what is the law. Mr. Bossar, do you have that judgment with you? Because Ms. Jahan, that we discussed in the first half also, that in the protest petition, those grounds has to be specified.
Just to be, it has to be quite similar to the complaint. It has to have all the grounds.
That is
That is what in the Naraji petition, 4-line Naraji petition will not do. That has to be grounds.
That's what this judgment also
Is it?
my lord.
This is bypass judgment.
Right.
That's what, para 10 is there.
My
Para 10, his lordship has clarified. Para 10, para 12.
Para 10, 11 and 12.
But if you go through this, Mr. Datta, that in his complaint
My lord,
and her complaint, that is protest petition,
my lord.
those grounds are not active.
Only ground that she has taken, there are witnesses, number of witnesses
No,
support the case.
that
That is the
cannot
only
be.
thing she has taken.
You know,
There, my lord.
that is her protest.
That is a protest. My lord. That
The
is,
thing
that,
is this,
Without facts and grounds, my lord.
that's what, in fact, what is a complaint, if you say to complaint, they have to specify.
yes, specific. And that's, that judgment, my lord, yes, my lord. Also, my lord. So then, my lord, but here, the only thing that she has stated is, my lord,
There is no such
no,
specific.
no such specifics, my lord. That is there.
In that case, as you know, Mr.
Just only one, just
Yes,
submit one
yes.
judgment, my lord.
Sure, sure.
That much-
We'll consider.
That much only because I cannot improve upon this complaint anymore, my lord. It is whatever is there, is there.
No, that's the law. right?
There's the law, my lord.
Because it becomes a complaint, and when it is a complaint, is defined in the CRPC. It
Yeah.
has to consist of those materials.
Yeah. This one judgment, my lord, where but the powers are there, my lord.
And probably she was not properly guided.
Definitely not properly guided because otherwise she would have found it
See,
properly.
basically, that is why, in fact, for this, I was not taking criminal bench for long. But anyway, what we found that in spite of these judgments, here, the recent judgment of the apex court, those matters are coming up. Rajneesh, you go through that judgment.
I'll take.
But in fact, you have noticed today there are 3 cases. In those 3 cases, Rajneesh was considered.
Yes. In fact, Rajneesh, I've already seen last night. It was passed under 142, Article 142, not 141. That, before the guidelines, the Honorable Speaker was right, that should be under 140. That's the difference.
No, it will not be mandatory.
But between justice, then done it. It's written clearly 140. But again, non-compliance, they have again issued notices to all, for recirculation of the judgment to all the judges.
Sometimes, you know, this, can we cross-check with other laws? Can we cross-check with other laws? Basically, what happens, you know, in SCC and all, the paragraphs are not similar to that of the judgments of the Honorable Apex Court.
They have their own copyright.
That's right. They are their own copyright. And then this time it was His Lordship, the Honorable Chief Justice of India made it very clear. There was a conference at Kolkata just before our summer vacation. There, His Lordship has taken out this issue that it is better to go straight away to the judgments report of the Honorable Apex Court. It is in the website. And the edited things are available after a week or 10 days. And he was just, by passing a remark, he said, see, our Supreme Court judgments are being sold at such a rupees. It was indicating.
Yeah.
Of course, he said that you can get it freely. Of course, it is free, absolutely free in the website. So he was also mentioning that the should go for the free site website of the Honorable Apex Court and they get the edited things after a week or 10 days. Then some of the journals like Manu Patra and all, they are not changing the judgments. Okay.
Yes.
No,
And
no.
they
Whatever is in
as it
the,
is.
what as it is. So kindly recheck with.
Yes.
Otherwise, the direction in the last part of that judgment would not have been there. Had it been only if it is 141, then only that direction is there. Somewhere just find out.
Check whether it's
You have to,
142
yes, or also cross-check with AIR
AIR
and the
Manu Patra, I'll
Manu
check.
Patra, check it out. In fact, you can also cross-check with the Supreme Court judgments that the free website.
Ah.
That is cross check. There is something that was also, if it is 142, why 142, directing us to cross check.
146, 136, this is what is written down.
Just verify. Mr. Datta, which paragraph?
My para 23 and 24, two just paragraphs are just placement, nothing more than that. My lord, what can the court do, my lord? The view expressed in Sushant Singh's case, in our view, is more acceptable, since the court has held that in the cases referred in here above, the magistrate has ample power to disagree with the final report that may be filed with the police authorities under section 170 of the code, and to proceed against the accused persons, dehouse the police report, which power the session court does not have till section 319 is stages rich. Here, of course, it was a question of committing matter. The upshot of the such situation would be that even though the magistrate has the power to disagree with the police report filed under section 170 of the code, he was helpless in taking recourse to such course of action, but the session judge was also unable to proceed against such person other than accused sent up for trial till such time evidence has been adduced and the witnesses have been cross-examined on behalf of the accused. In our view, the magistrate has a role to play while committing the case to the court of session upon taking cognizance of the police report submitted before him under section 173 of the CRPC. In the event magistrate disagrees with the police report, he has two choices. He may act on the protest basis of protest petition that may file, or he may, while disagreeing with the police report, issue process and summons to the accused. So he can do it suo motu also.
That's what. But what to be, when that is also there is a judgment, I'm sure I remember it. That when is not, the magistrate doesn't act upon the protest petition. And of its own, exercising his power as a magistrate, then he can proceed.
Here, my lord, he examines her, my lord. He examines her. That will lordship will find at page 46. I've been working. My
Please take your seat, Mr. Dutta.
Well,
No, rightly here, Mr. Dutta. Magistrate has that power.
Right.
But if he's exercising the power on the basis of the protest petition,
Right.
then the protest petition has to be on the basis of a complaint.
Right.
But if he's not satisfied,
Right.
sometimes it may happen, the final report is submitted. But without issuing any notice to the informant or the complainant, the being not satisfied, materials available, whatever it is, statement of
Right.
the
Right.
under 161 is available before it, or the medical report, or the, you can say, the other reports available before it. Magistrate can proceed
Right.
without accepting the final report.
Without calling the
Complainant or the informant.
But here, of course,
Once it is, the statement is recorded,
Right.
then that is on the basis of the,
200.
200 seat.
that is the difference.
Yeah, of course, my lord, he did not, my lord, he did not refer to the.
Exercise that power.
He did not refer in the page 50, my lord, the order. He did not refer to the complaint protest petition at all. He did not. He says that on perusal of the, of course, he had examined it in 200. On perusal of the complaint petition statement of the complaint. Complaint.
Where
Complainant.
is that complaint? That is, the procedure 200. This proceeding is under 200, right?
200. Yes.
Once it is 200, then there has to be a complaint. Where is that complaint?
That I think he refers to the original complaint itself.
That cannot be.
That complaint he
That
refers
once
to.
it goes, that is what the apex court has said. That the second time
That is
protest
the law.
petition Has to be a complaint. It cannot be on the basis of the first complaint.
Para 10 of this judgment is very clear.
Huh. No, that's true.
And the facts and circumstances are also similar. In here, while the complaint case was filed, which was transferred to the police for registering a jail case.
In fact, we have been discussing these issues because see, basically, if, as you know, that complaint petition file, if without mentioning, if it a complaint petition under 156(3) for sending of the matter to the police for recording a registering a police case and to investigate the matter, that particular complaint petition must have that the complainant had earlier approached before the police station by filing an FIR which was not registered. Then the 173(2) whether to the join the police by registered post or not. In spite of that, it was not done. And then only now they are approaching the magistrate under 156(3) for
Exactly right.
sending of the matter. But if there is no mention that earlier approached and filed and then followed 1 and 2, then cannot under 156(3) straight away cannot come. That's the law. Again, but we have seen the even today, that is what is difficult for us. And frankly speaking, looking at the academy, we've been doing so much thing, but even today we have been seeing that magistrates are doing the same thing.
So, it's too, actually, it's very, very technical now.
No,
It's very, very
CJM,
technical.
the CJM simply forwards the matter to the other magistrate, SDJM or the MFC for disposal. And what they are doing, similarly, without looking at applying their judicious mind, they will forward it to the police station. So it's over. But materials where it is that statement has been made by the informant or the complainant that the complainant had earlier approached the police station, not record. Now, after the full bench, the constitution bench decision, FIR has to be registered.
Right.
They cannot avoid. Earlier, it was taking some time, right? Now, so immediately we have to register. Just let us see the order of the learned magistrate.
Page 50, my lord.
Straight away under section 200.
200.
Now, once 200, where is that complaint? On perusal of the complaint petition, where is that complaint petition? That doesn't disclose, that is, if it is the protest petition.
Kindly have a look at the section 190 of CIPC.
True, in that case, it will be so auto type.
So more type. So more. Yeah,
Instead of
he can.
taking the statement of the complainant doesn't matter in there. And here itself says 200.
200. And after filing Naraji petition, she was examined.
Mr. Doctor, better.
No, but I'll lift the shot. Placed the judgment, my lord.
No, because of that.
That judgment I'm aware, my lord. That judgment I'm aware.
In fact, once,
My lord,
because
just-
here the magistrate had it been a 193,
My lord.
even after 193, the going to the materials in the case diary,
Right.
he could have,
He could have.
he may not have accepted the protest petition.
My lord.
And he could have proceeded on the materials available in the case diary.
That's what I'm saying. It's very, very, very technical, my lord, because one mistake here, my lord, and the thing stands a different way. Because had he not examined under 3 and 200, perhaps things would have been different. Just by writing, my lord, therefore.
Sufficient would have been that I have perused the case diary.
Yes,
the
well,
materials, and on the basis of I have.
So, my lord, that and
That thing is
lordship,
different.
but lordship will see the implication here, my lord. Because of that, my lord, just writing, I have that she's examined at 200, my lord, or she's being examined at 200. The investigation, my lord, now will be in a, my lord, has been put to an
What
end.
happened? In fact, we have been seeing, in fact, we've been discussing these issues. After the magistrate again, 156(3),
My lord.
there is no mention of first FIR or before the SP of the concerned district, the district. Proceedings. 156(3), and what happened? Everything goes ultimately. In fact, we have asked Ms. Jahan to look into a particular judgment. There is a judgment, it seems. Now, what will happen if on the basis of such kind of FIR, registered on the basis of the complaint forwarded by the magistrate under 156(3), and charge sheet is filed, cognizance taken, then what will happen? Now, thing is this, there are judgments where they say that if the initiation is bad in law, necessarily whatever the
Follows
cognizance
the-
taken will also follow.
Follow.
It will not
True.
come.
True, my lord.
But there is a judgment. That's what I have asked Ms. Jahan to look. There is a judgment. That where cognizance taken means there are materials. So that thing is little disturbing in the text. But I was trying to find out that judgment and also to get it. I asked Ms. Jahan to look into it. Here is a case here, not exercise 193. The exercise 200.
200 million. That is
only the 2D. Will differentiate.
Man. Obliged, man. And the learned friend is saying that the person is also retired from office, man. She is also discharging her duties now. Perhaps those things, whatever happened then, my lord.
No, in fact, sometimes it is the duty of the magistrate to, in fact, otherwise, correct? They can- Look into what? Heard Mr. Z. Basic, counsel appearing for the petitioner. You will appear, Mr. Busso?
He is not the party.
You know, the state is not a party.
No, my state is not a party because complaint case.
Mr. M. Dr. Learned Counsel. For the sole opposite party. Mr. Busso relied on the decision of his coordinating principle of past year. In the case of minor including Beckett Candy and others versus state of Assam and other. Reported in 2013 Food GLT 1038. On the other hand, Mr. Dr. Learned Counsel for the sole respondent relied on the decision of the Honorable Apex Court. Constitution bench. Constitution bench judgment of the Honorable Apex Court in the case of Dharampal and others versus state of Haryana and another. Reported in 2013, AIR 2013-301. Here, the issue, the judgment you have placed, the issue is because the committing court has the power or not.
Yes.
That is the why
that was
probably it was the full court. That is why the constitution bench took that decision. Because the power of the committing court, the similar manner it's a magistrate. That's what the apex court found that yes, the committing court has the power. Earlier, the honorable apex court was that the committing court has no such power. But here that the constitution bench comes that committing court has the power. And there the differences between because that again, the power of the magistrate and the power of the, because it was tribal by the sessions court. That is why. Anyway, we'll allow this.
Mal.
Was there any stay order earlier?
Yes, ma'am.
Yes,
There
sir.
was a stay.
The order is open.
Interim order passed earlier. Sometimes, yes, I have seen Justice Wi-Fi pass that interim order. Twenty-five 03201 stands marked with this order. Rise. Mr. Khan, we have allowed that petition.
Yeah.
And we'll send it back.
Your lordship will remand back this matter. Then my contention may be, your lordship, reflected. Regarding that hand note, your lordship, the hand note, one hand note was shown by my friend, your lordship. That hand note is self-made, that means there is no any signature.
The magistrate court under 138, they will decide.
Yes, yes.
Nothing else. Yes.
May I please, Lordship, item number 23, this matter may become impact first, Lordship.
Why?
Lordship,
The reason for Why it has become in foreclosure?
Lordship, it is a maintenance matter, Lordship. They've already settled.
Who is appearing for the other side? Who are the councils appearing for the other?
That's
You are appearing for the husband.
Yes, Lordship.
You have to have the other side. Maintenance matter. You can wait. Yes. go ahead.
My lord, item 26, I pray for fixing a date, my lord. This is quashing of FIR, my lord.
Most police station. What are the stays when the file is?
My lord, investigation was going on and there is a stay order. my lord.
So stay order is in your favor.
No, my lord, I am for the respond number 2, my lord.
Someone in the morning,
Yes,
26.
yes, my lord, yes, the other,
Main morning
Yes,
that
sir.
Mr. Bora is not
yes,
available.
my lord, the other side, my lord, took consent for taking time, my lord. I am only praying for a date, my lord. If possible in the next week, my lord.
Next week, not possible. Football refund. Well,
Yeah. Okay.